Yeah, and we've certainly seen which is the two worst of two evils discussion on the table more often than not, which is, I've saved up all of this money. I'm going to lose my everything,
Yeah.
and I can still close, but I'm choosing not to, or I just can't close because I'm in the situation that everything's dried up. If somebody's sitting at the table and they have that option to close, whether it's at higher interest, maybe not favorable conditions versus sitting in a lawsuit, in a very general statement, what's your recommendation?
My recommendation is to close the transaction. You better, if there's any lawyers listening to this, you better damn well be certain that you are right in terms of your view or opinion that someone can close and not have any additional consequences. For the most part, these deposits are a down payment, are someone's life savings. So if you're going to give that advice, you better be sure that you're right, because like I've said, these deposits, there's forfeiture.
And we are back with the Money, the Mindset, and the Mentoring podcast. And today we have Rob Sheldon of Travers Law in Ontario, in Canada. And we are going through such a major shift in real estate. There's been this massive boom that happened over the pandemic, and houses went to unusually high numbers. And then we had a shift. And all of a sudden, the thing that we kept on really washing over became one of the most important conversations that we're having today, and that is the law aspect of real estate. Most people would go to these different organizations and try to find the cheapest, the fastest, the easiest lawyers to deal with, and wouldn't get the advice that they were looking for. A lot of times closing, not even with the lawyer, they'd be closing with somebody who was not the lawyer that was named on the file. We've seen this. I own a mortgage brokerage. We know this stuff happens. And so you guys have come to the forefront because a lot of people are running into struggles where it comes to they bought that pre-construction, it's closing, they don't know what to do, and they need advice. So, Rob, thanks so much for joining the show.
Steve, thanks for having me here. I was going to say, yeah, you're absolutely right. The massive shift in the market this past 2 years, we saw, pre-pandemic busier than usual. And then during the pandemic, when everyone thought that everything was going to kind of fall apart, we saw the exact opposite. We saw a frenzy, homes going far more than what they probably should have been at that point, which now leads us to our decline this last year, interest rates going up, housing prices following suit and then not following suit, going down and creating a lot of problems. And the one thing I think is really important that you noted is there was an opportunity for people who didn't practice real estate, lawyers who just kind of dabbled in it here and there, to come on and make a lot of money, but do very little for their clients, not know what they're doing, just close the transaction and give some poor advice. With that said, most lawyers who practice are good, but there are some bad apples, just like any profession.
Absolutely. I mean, when I first got into real estate, when I first considered real estate, I had a lady, her name was Michelle Mason, and she convinced me to get into real estate. And at first I turned it down. I said, no way, all real estate agents are scumbags, is what I said. And she's like, Steve, do you think I'm a scumbag? And I'm like, no. And she said, well, then you don't have to be either. And then as I got into the profession and really started to get to know a lot of people in the industry, I certainly found obviously it was the opposite. There's a lot of amazing people in the industry. Just like in the law space, there's a lot of amazing people.
Absolutely.
But a lot of people are getting tough and bad advice. And so, when we look at resale and we look at new construction, two very different animals, what do we see from a law perspective that are some of the biggest pitfalls in those two different pockets of real estate?
Great question. I think the important thing here between those two areas, new build construction and resale, is that they're contract driven, okay, and the contracts are not the same. I was actually talking about this morning. Real estate generally has to be written. You have to have written agreements. For resale, we for the most part, 99.9% of transactions in Ontario are done off of the OREA forms. Slight differences between different areas, geographical areas that work together, but for the most part, these forms are pretty much standard. New builds are not quite the same. New builds are not 6 or 7 pages with a couple page addendum. New build contracts are generally 30 pages or so with schedules. When you add everything in, including all the terrain requirements, they can get up to 70, 80 pages standard. I had one three or 4 days ago. It was 400 pages in total. Very different beast.
It sounds so much like the real estate contracts are just like when the government puts out a new bill for the house to approve. They slap in 800 pages and get you to approve it in 24 hours notice.
Yeah. There's not much, and if you don't know what you're looking for when you're looking through these agreements, it can be it can take a long time, and a lot of lawyers won't do it. It's very hard to justify to a client, oh, I'm going to charge you $3,000, my hourly rate of, it's going to take me 10 hours to read this 700 pages or whatever, and I got to charge you for it. Where most lawyers who don't practice would, they just don't do it, and then they're just not doing the due diligence. You get a lawyer who knows what they're doing. They can pinpoint the areas in the agreement and bring to the attention the main points that a client needs to know prior to entering into that agreement or having it go firm.
Yeah, and when they go firm, they have that cooling off period, right? Like when they put the offer in, the technically they're not firm, but they've got the cooling off period.
Yeah.
And a lot of people don't use that cooling off period to their advantage to really get that work done. The amount of times we see people who brought their builder contract to us, and you ask them, who's the lawyer you reviewed during the cool off period? They're like, we didn't have one. And it seems that happens more often than not, and that's really to their peril.
Absolutely, it's to their peril. They're not going to understand that the purchase price on the very front page may not be what they're paying at the end of the day, depending on what's in, there's an adjustment section, there's HST questions, there's extras, there's delays, there's all of these clauses that are contained in these massive agreements that it's very important to bring to someone's attention. Like you said, they may not understand what they're getting themselves into.
The biggest thing that I always hear is I didn't know when they get into. I didn't know I was supposed to have it reviewed. My real estate agent didn't tell me. I didn't know. Is that a good excuse?
It's an honest excuse. It's not going to hold up any water, unfortunately. I get it. I understand. I'm a human being like you. We don't understand everything. But there is a cooling off period. You do have someone who's going to give you advice to say you should go and see someone. And I think a lot of the time, and it's probably changing a bit now given the circumstances of the market, but at the time, I think there was a lot of excitement and that blinded a lot of people. I just need to do this. Everyone else is doing it. It's a great investment. But without having someone review it, we see situations where they entered into that agreement 3 years ago. Markets changed dramatically. Had they known it was going to be 3 years, maybe they would have taken a step back and not be in the situation that they're in now.
Absolutely. And some of those things aren't even conditions around the market. It can be personal conditions. One thing that we see a lot is that first-time home buyer that goes out and buys the new construction, and they're thinking, okay, it's going to close in 2 years. That's perfect. I'll have all my down payment saved. Life shifts. They maybe lose a job. Or even more, they get transferred somewhere else and they can't now take that. It's not assignable. They can't get rid of it. Yeah. And then the project delays another 2 years. And now they've got kids. They might own another property and life has just shifted, but they still have that contract. And how enforceable is that contract? Is that something that, well, times have changed, I'm just going to walk away? How binding is that contract?
Good question. It's simply put, it's a binding contract. These contracts are drafted with substantial amounts of terms that are protective for the builder. The builder, and it's a two-way street. The builder's taking a big risk by, selling all these units with the potential of people not closing. So they draft them to protect the builder because the builder is going to be putting the money in, the investment, which is, people who are buying, when they're buying, don't necessarily see that side of things. I'm not saying this to justify any action by a builder, but the reality is, to answer your question, these contracts are binding, very strong, ironclad for the most part. There's a couple areas in the agreement where there's some wiggle room if they're not drafted properly, but for the most part, they are ironclad, and you are absolutely right. Circumstances change. I hear this question all the time. Hey, I bought this in 2020. Market was booming. I thought it was going to be great. It's now 2020. 2023 comes along. I've met my life partner. This is fantastic. She's pregnant. We're pregnant, whatever. And we can't live in a 500 square foot condo with a newborn and a cat and a dog and my unemployed brother. You know what I mean? It's just those circumstances are not going to be justifiable to say to a builder, can I get out of this because things have changed? Mm-hmm. There is some flexibility in terms of the HST section of these new builds for the government to have some understanding. Like you said, if you relocate, well, that's a life change. Maybe you'll be able to get out of the transaction, or have, and I don't mean get out of the transaction with the builder, but get out of a small portion of that transaction, an HS3 requirement, in terms of having a rebate or not. There's some flexibility there, but it will not allow you to get out of the whole contract as a whole. When you sign that, after that 10 days, you are bound, and your deposit or deposits become your, or the builder's security. It's your skin in the game. And so that deposit is important and can come into play years after the fact that you've paid it.
A lot of people look at the deposit and they think the deposit is where their liability sits. They buy a property, they're like, ooh, I'll put like 20 grand down, whether it's resale or new construction. Let's talk a little bit about what is the deposit. Is that where my limit of liability stops, or is there so much more that I need to consider?
So much more. The deposit it's a weird thing. A deposit it holds a bunch of different places in a real estate transaction. So is it a down payment? Kind of. When you close your transaction, it's applied to the purchase price. So in a sense, it's a down payment. But it's not treated as a down payment. It's treated as a deposit. And the big thing here is that deposits are forfeitable. So if you don't close that transaction, you forfeit that deposit. So that means 20 grand, 30 grand, 50 grand, 100 grand, it's gone. It's forfeited. You have not fulfilled your obligation. So what is a deposit? It's partially a down payment. It's partially a penalty for you not fulfilling your contractual obligation. Fundamentally, a deposit is it's funny, it's called earnest money, or it's referred to back in old times as earnest money. It's proof of your intention, your sincerity, along with your signature, your seal, to close a transaction. So it's performative. So it's all these things. It's a down payment, but it's also a penalty should you not close. It's your demonstration of your willingness to close the transaction. So people, I think it's a down payment, and they think that's it. Well, I paid it. I'm going to lose that. That's not the case. You can lose your entire deposit and still be subject to a whole bunch of other damages that arise from not closing that transaction.
New construction in 2021, 2022, builders were generally looking at, man, I really hope that person doesn't close, because they'd see maybe 2023, because the house is going up in value. The builder's like, man, I sold it for so cheap. I could make another 400 if I could just sell it myself. And so they were really excited about if you could not close on that. I've seen things where they ask for weird things sort of performatively throughout the process of, we need another pre-approval. We need another pre-approval as the closing process is going on. And so they just ask for all these, and if you don't give it to us, we're going to take the building back. And it's a very different market now. When we look at now, builders are requiring you to close because they know, that condo they sold for $800,000 is now probably going to sell for $600,000, and they're going to be sitting in a position of deficit. And so it's a whole different market around that. And when we look at that deposit, especially in new construction, what are some of the big pitfalls in those 800-page contracts that people don't read that they've committed to? Those things that are not just when we talk about the penalty, but actually what's going to happen that they're going to have to be held accountable for.
Yeah, you nailed it on the head. It was 2 or 3 years ago when the prices were escalating 8% every year, if not more. The builders were salivating at the idea of people not closing. And a lot of the good builders out there, and there are good builders out there, they weren't putting roadblocks up, but they were happy when someone said, "I'm sorry, I can't close." Because in that situation, they would relist the property. Let's say it was a $300,000 condo. Oh, hey, I can relist this and sell this now at $500,000. So I've just made a profit. And lo and behold, because a deposit, there's forfeiture of the deposit. Not only do I get more money from the market, I get to keep that $50,000, $80,000, $100,000 that the purchaser had put down. I'll sue them for that, and I'll get that. So they were, it was great. It was the greatest thing that could happen to them. I'm not saying that they were all out there with long fingers, scheming for this. Exactly, right? But when it did come up, they would say, sure, we're not going to, you don't want to close, we're not going to waste our time on it. We're going to make more money, and then we'll sue you for that deposit, and you will lose that deposit. Because there's some case law out there that says, for the most part, it's not the greatest case law. I think it doesn't make sense. But with that said, the Supreme Court has indicated that deposits, there's a two-part test, but 99% of the time, it doesn't really matter about the material impact of that deposit. The deposit's going to be there's forfeiture of that deposit. So
material. What you're saying is material impact and the forfeiture of deposit are really standalone in the way that they're viewed. Is that what my understanding is? Am I correct in that?
Yeah. So if you can apply for the courts to relief from forfeiture. It's what it's called. And so you can say, hey, given the circumstances of the transaction, I'm going to apply to the court to say, I need some relief here. I think I should be entitled to some, or if not all of my deposit back, given the facts specific scenario in which I've encountered. Okay. For the most part, very rarely, if at all, I can't recall any case that says, oh yeah, the material impact of with the transaction as a whole will allow you to justify your relief from forfeiture. And a lot of the time, what they'll do is they'll say, well, the courts will look at the purchase price and do kind of like what percentage of the purchase is of the purchase price is the deposit. And is it, and there's no set rule. This is the problem. 5% is that the balance where they start saying, oh, that's too much. You should give some of it back. There's a case that has 28%. That's over a quarter of the deposit, quarter of the purchase price. And that was not sufficient enough for the courts to say, yes, we will give you relief from forfeiture.
Wow. And so sometimes when you use the deposit, when you're going to resell, you'll use the deposit to show strength in the buyer. If there's ever a situation like that, you really are putting that into, you're amping up the penalty should you not close, rather than just saying that's going to be the deposit for your purchase.
Yeah, bang on. Absolutely. And that's why, buyers or sellers are saying, yeah, you have two agreements that are exactly the same. Which one has the higher deposit? Let's go with that one. Maybe that nice letter you got from the family with the young kids and the dogs, that's not going to play into it. It's generally going to be what's higher. How much money are we going to be able to extract from this should it go sideways?
Absolutely. I think in 10 years of real estate, I've never seen the letter really move somebody when there's a significant amount of money on the table.
Yeah, exactly. Yeah.
So now we're looking at it. We'll look at resale in a moment, but when we look specifically at new construction,
Mm-hmm.
in the contract, we've got things such as penalties, and interest, and all these other damages that can accrue, for the builder should somebody not close. What are some of the perils that you generally see that people need to look out for when they're signing one of those contracts or have signed that contract?
Yeah. I think they have to understand the time frame. That's one of there's HST implications. There's these are standard though, but I think the practical part of the transaction is what's called the Terrian statement of critical dates. It's a time frame in which, hey, the builder, we're going to have this thing ready for you, purchaser, at the earliest at this date and the latest at this date, and that could be 3 years apart. And as long as the builder's giving the appropriate notice, hell, even if the builder doesn't give the appropriate notice, the penalty to the builder is not substantial, given for the most part the cost of these homes. So at a maximum, it's about $7,500. There's some wiggle room about that in terms of how that's calculated, but generally speaking, the Terrian penalties for a builder not giving notice caps out at $7,500, right? But you're still locked in. So maybe the builder has to give you $7,500 at the end of the day, but they have that huge time frame in which the contract is going to be valid. So when you sign that contract, it's super important that you understand, one, that date on the front page may not be the date you're getting it, and two, it may be 2 years down the road. So if you're planning on selling your home, which happened over the last couple of years when the market was high, but then it's extended out your purchase and you don't sell your home and the value of that home decreases and you can't pull money out of the equity out of that home to buy this new build, you are in a bad spot. And that's happened. I've seen that happen a couple times over the last year.
Yeah, and we've certainly seen which is the worst of two evils discussion on the table more often than not, which is, I've saved up all of this money, I'm going to lose my everything, and I can still close, but I'm choosing not to, or I just can't close because I'm in the situation that everything's dried up. If somebody's sitting at the table and they have that option to close, whether it's at higher interest, maybe not favorable conditions, versus sitting in a lawsuit, in a very general statement, what's your recommendation?
My recommendation is to close the transaction. You better, if there's any lawyers listening to this, you better damn well be certain that you are right in terms of your view or opinion that someone can close and not have any additional consequences. For the most part, these deposits are a down payment, are someone's life savings. So if you're going to give that advice, you better be sure that you're right, because like I've said, these deposits, there's forfeiture. It's gone. And in an instant, in an overnight blink of an eye, that entire person's 10-year, 20-year nest egg is gone. So my view is always close that transaction and deal with whatever after you've closed.
Yeah. Yeah, when they don't close, they also have the idea that there's interest charges, there's penalties, there's loss of value, all these other things can stack up that sits greater than the value of that deposit.
Absolutely. This is where it comes back to how the deposit's really strange too. So in the scenario that we talked about where the builder had an increase in value, okay, and they sell the property for $200,000 more than what they originally had entered that contract for. In some people's minds, they're going to say, well, I'm going to get my deposit back. You're not going to get your deposit back. They're going to sue you for the deposit, and they're going to take all that money because they're entitled to it, because you promised when you entered into the agreement to fulfill your obligations. It's performative and it's a penalty, okay? The interesting part is that when we have a scenario where the property is decreased in value, the builder sold it for $400,000, market's crashed, it's now worth $350,000. That deposit is applied to the loss, applied against the loss. So when the builder makes a bunch of money, they get more money. They get this windfall. But when there is a loss there, that deposit's applied to the damages. And sometimes, if not most of the time in this scenario, those damages supersede or are larger than the actual deposit. So there will be scenarios where the builder will come after you after this is said and done for those damages, if they're substantial enough. For $1,000, probably not going to go for it. But if it's 50 to 100, they're probably going to sue you to get that money back because they've taken all the risk and they don't want to, if they can get some of that back, they can recoup it, they will.
And when you see in the contracts, it says things like the builder has the right to 24% interest on a deposit, blah, blah, blah. Can those be executed with full performance in the court saying that you actually owe that money? Or is that something that you give leniency to people, that judges give leniency on?
It's a great question. We have, as lots of people kind of know now, we kind of have more judges that are of the courts of equity mind. So they're really about fairness and reasonableness. But the law is the law. Okay, so if you entered into a contract that said the builder's entitled to X, Y, Z, you better have a good reason, a good argument against why they should not be entitled to that. And like I've said before, even when there's a windfall for a builder, and someone's asking for relief from forfeiture, a lot of the time they still lose that. So your argument of 24%, oh, I didn't want to pay it because it seems really high, it's probably not going to carry a lot of weight. It's part of the contract. Had you gotten a lawyer prior to entering into the agreement to review this, that would have been brought to your attention, and maybe it could have been negotiated down to something more like 10 or 12%, which is still very high, but the contract is the contract. Real estate is all written, and so your rights are as good as what's on the paper.
Well, and you bring up a very good point. It could be negotiated. And at that time, obviously, where there's a lottery system of like, hey, hopefully I can get this condo, your negotiative rights really seem like they're on the back burner. But at the end of the day, the person you need to be lobbying for is for yourself. And if the contract, in a great time feels really good, in a bad time it's going to feel really bad, you've got to look at all of those things. And that's where sitting with the lawyer, not the lawyer's clerk or the lawyer's, best friend or the lawyer's buddy or whatever that a lot of these online businesses were doing, but the actual lawyer who's going to give you that advice.
Yeah, you're 100% right. We get these contracts in, we review them, and I regularly have phone calls with everyone that I do a review for, and articulate the main 4, 5, 6 major points to say you need to be aware of this because there's cost implications here that I want you to be aware. I don't want you to be at the 11th hour all of a sudden, oh, I have $30,000-$40,000 of extra costs here that I wasn't aware of because no one told me about it. So I always make sure to inform people of those additional costs.
Yeah. One other one that's really funny. We started off the episode talking about to close or not to close. That's the question. Yeah. There's a third one that we haven't even talked about yet, which is to close or to kind of close. And the kind of close is where you buy that condo, but the condo corporation hasn't been perfected. And you actually have to rent your own unit. A lot of people don't realize this thing actually exists.
Occupancy fees. Yeah. And they can go for a long time. They can go for, I've seen quickly, couple weeks, 6 weeks. I've seen over a year. And it's interesting. Yeah. It's most people refer to it as rents. It is, and the makeup of what that occupancy fee is more important now than it had been in the past because of the interest rates going up. So these occupancy fees are made up of an estimated amount of common expenses, a estimated amount of property taxes on the unit, and then the big part is interest at the builder's, basically the builder's rate on the outstanding balance annually. So right now I'm seeing 8 to 9%. So you take a $700,000 home, you owe $600,000. Well, 8% of $600,000 divided by 12, that can be several thousand dollars on top of the other two components, the tax and the common expenses. So yeah, they're paying. I saw one yesterday, $4,100 a month.
Oh,
$4,100 a month. Yeah. And that's just the occupancy. You don't have access to a mortgage at that point, right? This is just, you have occupancy. You can occupy the unit. You do not own it. So that money, you got to have that money. And if you don't have that money, then you're going to be up that creek, because you're not going to be able to make your occupancy. And if you can't make your occupancy, you're in breach of your contract.
so if a builder is running off of bridge money on the way that they're looking at building, because there's some builders that we know on the back end from a commercial lending perspective that they have, you're saying that the buyer would be exposed to the builder's interest rates?
No, I don't think it's not like, it's not going to be bridge financing rates. It's not going to be that high. It's regulated. So it's just
Okay.
based off of but it's high now. It's percentage points above Bank of Canada rates. So right now we're seeing the numbers I'm seeing at about 8%. A couple of years ago, heck, this didn't even come it came into play, but a couple of years ago it was so much less, like half the cost. There's a benefit to the high interest rates for the deposit for new builds. People get money back now. So the money you give your builder, it's subject to interest because you've given it to them. It accrues interest, and the builder owes you some money back. But by no means is that substantial enough to offset any of these occupancy fees, as they've doubled, if not tripled, over the past.
So when we look at new construction and the risk that's associated with new construction, then we look at resale. What of the risks that are similar in the new construction to the resale? Is there any advantage in risk mitigation in buying resale compared to new sale?
I think for the most part, your deposits are less. In resale, you have more negotiation in terms of your deposit. So you're protected a bit in terms of how much you put down. The market's shifted now. I couldn't say if it's more of a buyer or a seller's market. I think it depends on the property, where it's located. But there's definitely a shift. It is not just 100% a seller's market anymore. So you have some control over what that deposit's going to look like. A lot of the damages, the costs associated with not closing a transaction are similar. If you default, as noted earlier, you have to pay the builder, a daily interest on the outstanding principal. And you're saying 24%, that's a substantial amount. That adds up pretty quickly. Well, if you buy something in the resale and the other person has a mortgage and maybe bridge financing, well, you're going to have to pay their interest as each day goes on, and that can add up pretty quickly. You have a home, regular, normal, everyday person's bridge financing is about 12%, 12% right now. So that can add up $100, $150, $200 a day, depending on the amounts. So the main rule here, the takeaway is damages are subject to the fact scenario. Sold So the takeaway here is that the damages that are measurable for the person who defaults, so the purchaser who doesn't close that transaction, those damages are specific to the transaction. So if the person doesn't have a mortgage, isn't paying interest daily, well, then the damages are going to be a little less. If they have a mortgage or two in bridge financing, then all of those costs are going to be accrued and accumulated, and that buyer who failed to close that transaction is going to be responsible for those damages. Legal fees as well, insurance, relisting. There's a whole bunch of things that will be factored into damages, and they will be, again, fact specific.
When we look at resale, the only time I've ever seen when it comes to close or not to close, and I've seen this where buyers get upset because, the stove's not working, or the dishwasher, doesn't work to its level, or they just thought the paint color was fuchsia and now it's actually beige. Whatever the issues are, is there a level of performance that has to happen on maintenance, or a level of dissatisfaction that they can actually use that as a lever to get out, or is it considered as non-material in the grand scheme of things?
Again, you're doing great. You nailed it. It's material. So the general rule here is, does it materially impact your use of the property? So you're buying $1 million home. Hey, that fridge, that crisper is broken in the fridge. I don't want to close. I want them to put a new crisper in the fridge. That plastic container.
The
crisper.
crispers.
Yeah, my lettuce is just going to wilt. But I see that, and my response is always, that's not substantial enough. It's not, it's insignificant proportionate to the property. It will not materially impact your use. I have seen cases where the basement floods, and the judges say that does not materially impact your use. There's a solution here. They're gonna the person had insurance. And so you're refusing to close the transaction, even though there's insurance coverage to cover this. And the other side has come up with a solution as well with a holdback or whatever. So to answer your question really specifically, there is very, very little in terms of material impact on a house that will allow someone not to close a transaction. And there's a lot of confusion out there on people's buyers' rights. Okay. There's something called material, a sort of fundamental breach. And then there's just breach. Okay. Just because the dishwasher's not in good working order, that's breach. Sure. It's breach of contract, but it's not fundamental breach of contract, and you will not be justified to not close based on that. If there's a fundamental breach, something that goes to the root of title, you're not getting what you bargained for, they actually didn't own the property and they sold it and now you can't have it, well, sure, you don't have to close. But if it's not something that's material, then it usually turns into a post-closing lawsuit between buyer and seller.
And those would handle in relationship to the size of the real estate transaction, or in relationship to the size of damages? In other words, small claims or in superior?
Yeah, most of these things are small claims. Small claims is $50,000, so that's for the most part, it's big enough to cover these things. Like if you have to go and get your basement redone, $50,000 generally covers it. If it's outside of insurance coverage, right? Because you got to remember there are things in the agreement that are there to protect both sides, i.e. insurance. So when you're suing something, you're going for whatever, you're going to make yourself whole. You're trying to say, well, can I be in the same position as I was had this not happened? And most of the time it's under $50,000. If I'm going to be perfectly honest with you, it's a lot. It's just not worth it sometimes, for the most part, to try and say you're going to sue someone, because the reality is, if that fridge isn't working, it's not working the way you wanted it to, are you really going to try and sue someone in small claims court and be successful over a year period and throw $2,000, $3,000 at the issue when you could have just bought a brand new fridge for $1,200 and had it dealt with in a week? So there is a practical reality here.
Yeah, I keep this sign, nice and heavy with me, no negatively allowed. And I think sometimes, focusing on small problems, makes you make small decisions when you can focus on a big future and some other bigger outcomes. You're going to see happiness, you're going to see positivity, and you can move forward.
Absolutely. Yeah. 2 years of lawsuits, $1,200 isn't worth it. You will not remember on your deathbed, you're not going to remember the $1,200 that you had to spend on that fridge because you used that fridge and everything was fine. But you will still be upset about having to go through court for years over something that big. So you got to weigh it. You got to say, what's in my best interest here? And it's frustrating and irritating and not right in most people's eyes, but it is an unfortunate reality of these types of transactions.
That's why I always laugh at the clean broom swept condition clause, because you get those people, well, they didn't sweep the floors, and and you're like, yeah, okay, what would you like to do about that?
We had someone call us and complain to us about three cloves of garlic that were left in a cupboard. Just three cloves. My response was like, is there a garbage can around? Because you can just put them in the garbage can. It's not impactful at all.
Just go make some spaghetti sauce.
Plant it. Maybe it'll come up and you have 12 things of garlic. Who knows? But yeah.
That's right. Yeah, it's always a difficult situation of those final
Mm-hmm.
walkthroughs where then it goes to it's like they're doing a PMI on a new
Yeah.
car or something, and it's not really what that's intended for, unless it's something, as you say, use the word
Mm-hmm.
material. Then it's something that definitely, like, maybe the furnace isn't working, and you just want to
Yeah.
note that, or something major that is catastrophic. I mean, we had one where nothing ever showed up in our final walkthrough. The roof was just pouring
Yeah.
water in, and there was just massive damage that was happening. And it's like, wow, thank goodness it actually rained
Yeah.
today.
Well, yeah.
And at least we were able to monitor, but we were dealing with two like-minded people. So the sellers, were just, we will deal with it. We will solve it. We will handle it. And the problem went away because they were just beautiful human beings. And like minds got together and everything was okay. But yeah, those are always tough. Those final walkthroughs, it's a funny thing because, small things become big problems.
They do. And then this is where, to bring it back to our original conversation about deposits, this is where emotions get really hyped up, and the lawyer who doesn't know what they're doing gives bad advice, and people then lose their deposits. Hey, you don't have to close. That window at the front that's broken, we're just going to refuse to close. Let's refuse to close and see what happens. Well, if you want to do that, one, that's not enough. That's not even remotely close enough to not close the transaction. And two, again, you're playing with someone. You better know what you're doing, for your own sake as well, for all those lawyers listening, because you'll turn around and get sued yourself.
Yeah.
You give poor advice. You're not. We as lawyers are trained, or should be trained, and have a sufficient knowledge of practice to not just get blind instruction from clients, but to question when these things come in, and based on our experience and knowledge, manage the situation, manage our clients, manage expectations, and manage the relationship with the other side. That's how you get a resolution, where everyone is either unhappy, which is apparently the hallmark of a really good outcome, or they really are happy because the deal closed when it was going to close and we got it sorted out. So the knowledge of the lawyer is very, very important. And if you go with someone who doesn't have those skill sets, if you want to go with the cheap person, you get what you pay for. Yeah.
Yeah. Well, the one thing that I find is and I'll toot your horn a little bit here because I've been dealing with you guys. I've been in real estate for 10 years, I guess now, 11 years almost. And I mean, you guys have been there the whole time. We've had a lot of clients deal with your organization. And the one thing that always happens is a lawyer gets on the phone. And that is just something that I say is just so critical. We've seen these ones where lawyers come up where they have, I think they're notaries or something who do the signing appointments. They're not even the lawyer. And the law clerk is the only person they ever talk to. And some of them don't even talk to the law clerk. They talk to the customer service person. And so you're so far divorced from good law advice, legal advice. And that's one thing you guys have always stuck to is really to the purity of providing great legal advice, both to the real estate agents and mortgage brokers, as well as to the buyers and the sellers. And I give you guys a lot of credit for that.
I appreciate it. And I think we've learned, all of us in our own way, that put the effort in, because it solves problems. When you kind of, put your head in the sand, kind of avoid it, all you're doing is kicking the problem down the road, and you're not actually dealing with it and addressing it. I get it. Some people don't want to have a hard conversation, but that's what we're paid for as lawyers, is to say, here's your rights, here's what I recommend. And it's very important for clients to be able to talk to their lawyer. And, it might take an hour longer than they would have liked, but we get on the phone, we have a conversation with them, and we try and work it out so that they understand what their obligations and what their rights are. Like you say, it's very important for the lawyer to be involved.
Well, the best advertising, people ask about, hey, how should I grow my business? Yeah, I know it's tough. And then most people come to me to talk about their best marketing strategy. And the thing that when they look at marketing, service is senior to sales. And that's one thing I think you guys really take to heart, is the idea that if you lead with really good service, sales will come. And when you look at when tough situations happen, that's when your character is going to show. And that's really going to set yourself out from somebody else. If somebody gets into an emotional quandary and they're just not operating at their highest performance, and you're really operating with that high degree of emotional IQ and helping them navigate a very difficult situation, they will remember that until they go to the grave. And they will tell all their friends about it, and that is your best advertising. And that's why having the lawyer get on the call and talk to them and give great advice is one of the most important things when looking at evaluating, in my opinion, evaluating a really good legal
I 100% agree with you. And the reality is there's a financial cost to that. So you go with the person who gives you the quote that's $800 less. It's a red flag. You're not getting a deal. Because at the end of the day, you're not going to have someone who knows what they're doing. You're not going to deal with the lawyer. Heck, there's a couple organizations that there's paralegal organizations that lawyers, I know of a couple, that will farm all of the real estate out to them. So that the lawyer it doesn't even happen in their office. They just get it. They refer it out to another organization. That organization takes care of everything. The money goes into a lawyer's trust account. The lawyer signs off on one thing and that's it. And then the lawyer charges them for it and collects the money. So they're not doing anything. And we focus on real estate. It is the bread and butter. It is where our knowledge is, and it's what we're good at.
Yeah, and I think when anybody's looking to consider a good lawyer, number one, look at how much time they spend accessing the community and providing extra value. I know you guys have your movie nights. Not that defines a good lawyer, but you're just giving back to the community. And the idea is, are they accessible? Do they do presentations at the different offices for real estate? And that's how you really find out, is this person actually engaged in the real estate market? And that's how you can figure out. And so for anybody who's in the Southern Ontario market, definitely Travers Law .ca is where I would highly suggest you go take a look. We've known them for a long period of time. They've done our transactions personally and a lot of our clients, and we have nothing but great things to say about you and your team. In fact, we got some good accolades just 2 days ago for some closes. So really, really good job. Well, Rob, thanks so much for spending time with us today. It's been super helpful in unearthing something that is one of the most important people things are talking about right now is if I'm in a situation, I don't know what to do with my real estate, who do I reach out to? And definitely make sure you have a good real estate lawyer.
Perfect.
And guys, this is the money. This is the mindset. This is the mentoring podcast. We'll see you on the next one.